again, this is Andrei Minkov with the Trademark Factory. In this video, you will learn about the registration process for trademarks in Canada. The registration process is quite long here. The first step is to search if your brand can actually be registered as a trademark. By the way, unlike most firms who charge several $100s for it, we do it for free. So if you're not sure if you have something trademarkable, go to the homepage of trademarkfactory.ca, fill out the form, and request the free, no obligation, no strings attached trademark search for your brand. In some cases, you may also want to search for unregistered trademarks. A prior unregistered trademark will not automatically make your trademark unregisterable, but it may be the basis of an opposition proceeding or a lawsuit in the future. The rule of thumb here is to imagine a situation when you discover that such an unregistered trademark exists. Will you stop using that mark in your business? If you answered yes, I'll probably look for a more unique name. Then conducting a comprehensive trademark search is a good idea. If you answered, I'll take a risk, then the search would be a waste of your money. If you would change your brand in these circumstances, then it's a good idea to conduct the search. Most businesses, however, would choose to take the risk. If this is the case, then there is no reason to spend money on the optional search, because no matter what it reveals, you're still going to do what you were planning to do. After you've confirmed to yourself that you have something trademarkable, you file the trademark application. In this application, you need to describe the trademark, set out the products and services in association with which you're asking the trademark to be registered. You also need to state the basis of registration. The two most common bases of registration are use in Canada and proposed use. You would file your trademarks with the use in Canada basis if you're already using your trademark in Canada. I explained the meaning of the word use in trademark context in one of the previous videos, but to recap, a trademark is used in association with products if you place it on your products or their packaging. And it's used in association with services if you display the trademark while rendering or advertising the services. Alternatively, if you're only planning to bring your trademark to the market, you would use the proposed use basis. And remember, one of the benefits of trademark registration is that you can protect brands that have not yet been used. The application is filed online together with a government fee of $250. Then, the application just sits in the Canadian Intellectual Property Office for 6-7 months without anybody looking at it. Then, a trademark examiner will finally look at it in about 6 or 7 months, and in 70 to 75% of the cases, the examiner will find something that they don't like about your application, and they will send you what is called an office action. It could be that you missed another trademark that may prevent registration of your trademark. It could be that your trademark is not registrable because the examiner considers it to be clearly descriptive or deceptively misdescriptive. It could be that the way you worded your statement of goods and services is not specific enough to meet the required standards, and it can be a dozen other reasons. If you receive an office action, you will have 6 months to respond with your reasons why the trademark should be registered or with amendments to make the examiner happy. If this satisfies the examiner, you're all set. Otherwise, you will receive another office action. You only get 2 kicks at the can. If after your second response, the examiner is still of the opinion that the trademark is not registrable, your application will be refused. If you convince the examiner that your trademark is registrable, your application will be approved and then published, or as they call it, advertised, in the Trademarks Journal. Publication of your application in the Trademarks Journal opens a 2-month formal opposition period, during which anyone can file a statement requesting that your trademark be denied. This is a rare occurrence, but it happens every now and then, especially if your trademark happens to be similar to a well-known trademark owned by a corporation with a substantial legal budget. If you lose the opposition proceedings, the trademark will not be registered. If nobody contested your application, or if you successfully defended it during the opposition period, your application will be allowed. Now you will need to pay another government fee of $200. At this point, if you filed your application based on Use in Canada basis, you will get the certificate of registration of your trademark. If you file the application based on the proposed use basis, you will need to file a declaration of use, informing the Canadian Intellectual Property Office that you have started using your trademark. Once you file a declaration of use, you will get the certificate of registration. Again, this is a long process that normally takes anywhere from 18 to 24 months. If you are among the lucky 25% and you don't receive an office action, you may be done in about a year. If you're unlucky to attract opposition proceedings, the process may take as long as 3 to 5 years. There are 3 ways to register trademarks. You can do it yourself. Technically, you're not required to have a trademark agent assist you in the filing of your trademark application. The only advantage is that you'll be able to save on the fees that a trademark professional will charge you. The disadvantages are that it takes a lot of time to learn how to properly file a trademark application and, more importantly, how to respond to office actions. If you look at the trademarks database, you will see thousands and thousands of trademarks that were abandoned after the applicant received the first office action. Unfortunately, this is what often happens when you file a trademark application yourself. If your application is rejected, you're not going to get the government fee back. The second option is you can use other law firms or trademark agents. The advantages are that you will have significantly better chances of getting your trademark registered compared to when you do it yourself. A professional is going to do the work for you so you can focus on building your business, not trying to become an expert in trademark law. The main disadvantage of using other law firms and trademark agents is not that it's expensive, but that it's unpredictably expensive. Call any law firm and ask them how much it would cost you to have them assist you in registering your trademark, and you will receive a 2-page schedule of fees detailing separate costs for every tiny step that they would be taking to get your trademark registered. The cost will vary dramatically depending on the complexity of the case, and often there is no way of predicting whether the trademark examiner would find something improper with the application. I know of many cases when a $700 filing became a $5,000 file. The other disadvantage is that if, despite all the hard work, your trademark is rejected, you will still have to pay for the services, even though you got no benefit out of it. It's because the vast majority of other firms charge by the hour, not by result. And finally, you can use the Trademark Factory. We are the only law firm in the world that offers trademark registration services with a triple peace of mind guarantee. We guarantee that you will know the entire budget to a penny before you spend a dime with us. We guarantee that if your trademark application is rejected, you will receive all of your money back. And we guarantee that each trademark application is reviewed by a registered trademark agent before it's filed. This minimizes the risk of your trademark being rejected. The reason we call this service the Trademark Factory is because we have a well-oiled machine to get your trademark registered, guaranteed. Having said that, you will never become another statistic for us. We treat all of our customers very personally and guarantee that you will love our customer service and that you won't be frustrated with not getting through to your lawyer when you need him. We did our best to make choosing us as your service provider as easy as possible. If you decide that you will benefit from registering your trademarks, the Trademark Factory is an obvious choice. In the next and final video, I will share with you a few tips and tricks that will help you in your brand strategy. Got any questions? You know what to do. Call me, email me, or go to our website at trademarkfactory.ca or read my book, The Ultimate Insider's Guide to Intellectual Property. Thank you for watching. Talk to you soon.